Hello everyone, and welcome back to another episode of the Darrell Brooks saga. On today's episode, we're gonna continue with the pre-sentence hearing. We're gonna include this episode is gonna include topics as when it's gonna be, and as well as the shackles rant. So it's gonna be a fun one. Before that, I just want to say thank you guys. Thank you guys for supporting the channel. Thank you guys for liking the videos. We're trying to get back to the channel to the algorithm, so I really appreciate each and every like. Also, I don't mention this often, but I have the link to my coffee page. It's basically, it's like a donation / tip service that they have. And I don't plug this often because I don't really like to talk about money and stuff. But I'm in a tough spot right now. So if you are in the position of, any help will be appreciated. But I'm not gonna mention that really often. Without further ado, let's get right into the video. As always, link to the original video on the description below. All right, let's do it.
Case number 21 CF 1848. May I have the appearances, please?
State by Leslie Basie and Zach Witchow.
Sir, please state your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and state for the record that I do not identify by the name stated.
The record should reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is appearing in jail attire today.
He still keeps going with the script. I mean, I don't know why. I don't know why his red folder, he thinks that his red folder is so powerful that's going to get him out of this.
The court is here to address a couple of things. Of course, the scheduling of sentencing. I also want to address a letter that was sent to the parties late last week on the 28th regarding the unsealing of search warrants, a filing from Mr. Brooks, and then an issue just as it relates to the record and the use of restraints during the trial, given a statement that was made by Mr. Brooks when the jury was coming out after they had reached their verdicts. So I'll start with the search warrant issue. The parties should have received the letter dated October 28th, advising the parties that the court will be unsealing all of the search warrants tomorrow, November 1st, unless there's an objection that is raised. Of course, that's based in law and fact. And I indicated in that letter we would address any objections at this hearing. So I'll start with the state. Do you have any objection to that?
No, Your Honor.
All right, Mr. Brooks.
I have not received anything. I'm quite sure.
Remember that he doesn't receive anything. He always accepts for value and returns for value. So he never gets anything.
Or I don't know if you knew, but the very second that I left your courtroom Wednesday, Your Honor, I was told that it was.
I just muted that because I don't know if YouTube is gonna say something about it. So, but he was on watch. Let's just say that.
Per jail administration, that it was policy. It was nothing I could do about it. They immediately took me right from court, stripped my cell. I talked to mental health. They changed me right over into the smock, and I was basically placed on that. They just gave me regular clothes maybe 10 minutes before I came to your courtroom, Your Honor. So I haven't. I wasn't allowed any
We'll give
mail.
it to you.
Huh?
I had the letter printed off, and we'll give it to you now so you can take a moment to review it. It really says everything that I just put on the record just now as well.
I accept for value in return for value this document. When was this letter? Because like I said, I've been on watch, so I haven't been able to obtain any mail whatsoever. Not from the courts, not personal mail, not anything.
So that was signed on Friday and then sent over. I'm not sure if it was emailed or if it was just delivered to the jail. I don't know if Madam Clerk has any information. It was done by my other clerk. But in any event, you have it before you. I had, at the request of the parties and with the consent of all parties, sealed or continued the seal on all of these documents, and the previous order indicated that everything would be unsealed either November 30th or at the conclusion of the jury trial, whichever came first. Of course, the jury trial is now concluded, even though the case hasn't gone to sentencing. So my intent would be to unseal everything tomorrow.
Remember when he said that he wanted everything public? That the witnesses, he wanted everything to be public because it was a public trial. Let's see if he holds on to that conviction.
You have an objection and it's based in law.
I have, like you said, this is my. I didn't even know that this was even sent over to the jail until right now, until you told me.
Understood. Do you have an objection to what I
Yeah, but now you have it, so tell us what you think about it.
propose to do so?
I don't even understand. What do you mean by sealed and unsealed? I don't.
It would become a matter of the public record, and anyone could review those search warrants if they make a request.
Search warrants for what, property?
There's a number of search warrants that have been sealed as it relates to this case.
I don't see why they need to be unsealed at this point. Everything's pretty much been public already.
And again,
Right.
he brings out his "it doesn't matter what happens" defense, which is a bad argument. Say something about it. Don't say I don't know why. So because if you say it doesn't matter, they're gonna say, okay, we're gonna unseal them.
Well, I am going to unseal them effective tomorrow. The next issue I want to address is I want to make a record specifically as it relates to the restraints that the Sheriff's Department utilized during this case, given a comment made by Mr. Brooks when the jury was coming out the very last time. I don't recall if you said something about a stun belt or shackles or something to that effect, but it was inaccurate. I have asked the Sheriff's Department to provide photographic documentation of the shackles that were utilized in this case. An inmate who's in custody but in trial, a soft restraint system is utilized, primarily so it's soft and not heard, and then it's attached to the table so that it confines the inmate to a small area with that table. Obviously, during the trial, Mr. Brooks was able to stand. His hands were free, but I felt it important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public, and that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system, and it will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
Why would that-
the record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to.
He just told you why. Because people they don't need people to know what they use. So that way they can avoid them trying to like escape of it and no workarounds around that. So that's why. And also now he's complaining about something being sealed when he said before, right, like 5 seconds ago, he said that why the stuff should be unsealed. So he's really inconsistent.
to restate them. So
Well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
there was no shock device on
It
your
was a
ankle,
shock
sir.
device. I was told it was a shock device.
Mr. Brooks.
And
That's
My first question to him about that, if I had it in front of me, I would be like, who? Who told you that they were a shock device? That would be, and he wouldn't tell me because he's just what he is. He will be sneaky. Probably no one told him about it and he's just making it up. But
why I'm
covered
making
up.
the record.
It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks.
no, it was because they didn't want them to know that you were shackled at all. That's the same reason why they gave you suits to borrow. That you chose a horrible pattern to wear, but that's what they provided those suits to you, so they didn't know that you were in prison. So that you can look better to them.
I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect your
of
ruling,
those
but
as,
it should be noted.
Your
It should be
objection is
noted.
noted for the record.
It
Your-
should be noted that I had a shock device on my ankles. That's fact.
It
It's
is
a
not
fact.
fact, sir.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to require about what's being put on my body.
So he's gonna require what's being put on his body. And I look at photographs of shock devices. It doesn't. You need like a big piece in order for them to be able to give you a shock. So it was just a strap.
I was told that there were a shock device,
By whom?
which I know how a shock device looks because I've been through this before in Milwaukee, so I know what a shock device is.
You know nothing, Darrell Brooks.
It was clearly a shock device that was purposely not shown to the jury or to the public, purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
All right,
public
Mr.
doesn't
Brooks,
deserve.
you're-
the public deserves
You've
to
made
know.
a record,
The
and
public
it's
deserves
noted.
to know about
And-
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this
It's
voltage.
absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photograph.
Well, show
that
the
will be
where's
part
the
of the
photographs?
record.
Where's the photograph?
And again, she's trying to say that the judge is lying. You think that she will put her whole career on the line for you? Really?
And they
You
will
just
be
said they would be sealed. Why do they need to
from
be
public
sealed?
view
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right,
Here
so
we go again. He cannot. That's his only argument that he has.
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today,
It-
but I need to move
I don't
on
want
to
to be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown.
Yeah.
That's
That's
not
why I
right
had
at
a
all.
chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth.
The judge and the court is the same thing. If you say court, you're referring to the judge. If you say judge, you're referring to the court. No, they're not separate entities, as far as I understand.
Truth to be told. That should not be sealed. If everything else could be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your
Well, it's
characterization.
not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks,
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need
There's
to move
public-
on to
Not always. When they're on break, they mute you. I'm sorry.
There's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury.
All right, I'll say this before, but I would have loved to be there when he said that. When he said, I had a shock device on my ankles, and I addressing it to the public. If I were on the public, I would have been good. I would have been put in contempt and put in jail, but it will be worth it. I'm just saying.
That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason why.
advising you.
And I always had the chair right here. Everybody that came in this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why
any
did I have a
further,
black cloth
any
in front of
further
the table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold me
letting
in
move
contempt.
on
That's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me
All right,
then. Remove me
Attorney
then. It's
Basie.
not gonna stop the fact that they need
All
to know
right,
that the shock device
he's
is on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll make the
That's
appropriate
fine. Tell the
findings.
truth, though, Your Honor. Tell the truth. I had a shackle.
Lieutenant.
I had a shock device
Captain,
on
can
my
I
ankles.
please see you? We're off.
We're-
Appearances are as they were before. Mr. Brooks, if you interrupt me, I will mute you so that I can make an adequate record
You
regarding.
don't mute me anyway, Your Honor.
All right, he
You're gonna
interrupted.
mute
I
me
will mute
anyway.
him. I need to make a record of his removal.
He really likes to try to dare the judge to do something, and the judge is gonna do it. She's just gonna be okay. I'm muting you.
The court did warn Mr. Brooks repeatedly that if he continued to be disruptive, the court would remove him to the other courtroom. It was my sincere hope that that would not need to take place today. I gave him the final warning, and then I indicated I would be turning to the state to ask them some questions, and if he interrupted that process, he would be removed. He immediately interrupted that, and so the courtroom was closed. He was put into the other courtroom. He was audible for a little bit when I first went on the record, but he continued to be disruptive, and so I did utilize the mute function of the technology so that I could make an adequate record. Although this is really a scheduling hearing today, I will make a finding under Illinois versus Allen. He was disruptive. He interrupted multiple times and challenged this court when this court was making a record regarding the restraints that were utilized throughout this trial. It is absolutely false that a stun belt of any kind was used on Mr. Brooks. I don't know if he's receiving that information from other inmates, but that was not utilized in this case. It was a soft leg restraint setup, if you will, where he was shackled his ankles with the soft restraints and the soft strap so that it did not make noise. That was all attached to the table, and it is absolutely true that there was a black table skirt on the tables, both the state's table, the defense table, in this courtroom, despite Mr. Brooks believing that it was not done for his benefit. It was to shield that information from the jury. We don't, frankly, need inmates doing research or the public doing research on what these restraints are. There's an important security aspect related to keeping courts safe, keeping inmates safe, and that is why I'm sealing that information from public view. As far as Mr. Brooks being in the other courtroom, again, I did that pursuant to the authority found in Illinois versus Allen. I did not hold him in contempt. Frankly, because it's a scheduling type hearing, I could simply have him taken back to the jail and he could appear by phone, but I've chosen to have him appear by video and audio means from the other courtroom. With that,
I mean, she's still giving him all the advantage. She's helping him. She's giving him the opportunity to be there, to, I don't know, to keep on with the trial. Well, not the trial, but the proceedings. And he keeps kicking around. Like, he turned something very small, something that needed to be just sealed because something that he said, and made it a big deal.
I am going to address scheduling. I will be asking each party in turn how much time they believe they need to present their various sentencing remarks and whether anyone will be speaking on behalf. So I'll turn to the state first.
Thank you, Your Honor. To date, we have indications from the victims or their families that 36 people would like to either have a statement read or they'd like to read it themselves. We have approximately 5 to 10 others that would like to submit one in writing, which obviously wouldn't impact the time that we would need on the sentencing date. I would think that the state's comments would be between a half an hour to 45 minutes in total. So we're looking probably at about 4 to 4.5 hours. We will need some time to rotate victims out of the courtroom as they come in and to speak, because we can't fit everyone in the courtroom at one time. And speaking with the families and the victims Wednesday after the verdict, I think there's a strong desire to have the sentencing before the anniversary of the parade incident.
Sir, I have unmuted you if you could
I
speak.
mean, that's fair. I mean, I'm sure they don't want to be there when the anniversary rolls around, or they don't want them both to match.
To scheduling.
I know you're well aware that I have ongoing matters in Milwaukee pending too. I have to be in court there in 2 weeks, and those cases are scheduled for trial as well. I haven't had the opportunity to speak with my representation over there because of the protocol that I've been on. If it pleases the court, if it pleases you, Your Honor, I would...
Notice that now he wants something. Notice how after a few minutes ago he was irate. He was trying to... He was yelling at the judge. But now he wants something. So look at the way that he talks right now.
At least like to get a disposition on what might happen there. I go to court there in 2 weeks. I'm sure that I would learn a lot more at that time. I'm not sure if I'm going to have the same representation at this point or if something's going to change with that.
Do you
So
know
that's
the
something that-
specific date that you're scheduled?
The 17th. That's for both cases. I don't know why they put both cases on the same date. And like I said, I don't know if anything's going to change between now and then. But both of those cases are scheduled to go to trial. And like I said, with the representation there, I don't know what's going to happen with that as of yet. There's been issues for months with that. I know that's something that Milwaukee has to deal with and not your court. But it would be a great help to me to at least be able to find out what I can find out about what can possibly happen there, and to also do any work that I may need to do on my end to prepare for that.
And notice that it's been a year after that, and he still hasn't finished one of those trials. I think he pled guilty on one of those, but the Erica Patterson one is still pending.
So I have looked at the dates. You are right. There's a hearing on the 17th at 2 p.m. The trial, though, in that case is not scheduled until December 12th. So my belief would be I could certainly see the judge in that case understanding if we had to go to sentencing, or I chose to go to sentencing on those dates. And it looks like, again, both cases are scheduled for those same dates.
Yeah, it was kind of weird to me. The way they scheduled both cases on the same day was just kind of like, I didn't really understand why they did it like that.
Maybe they wanted to be efficient and get them both out of the way at the same time.
Well, let's talk about a related issue, and that is, do you anticipate anyone speaking on your behalf at the time of sentencing?
I do.
All right.
I do.
And do you know how many people you anticipate speaking on your behalf?
I don't know an exact number, Your Honor. Rough estimate there be 20 or more.
20 or more people. I don't think he knows that many people. And if you guys, I'm not gonna spoil the next episodes, but there are not that many.
Essentially, some people will be traveling to Wisconsin from different areas, different states, and I know they've expressed wanting to be there to speak for that. But like I said, me myself not being able to have the opportunity to speak with them personally, I haven't been able to reach out. Obviously, I can't reach out from where I'm at, collect call wise.
Why not? They're your friends. Just ask for their numbers and call them. I'm sure they'll take the call if they care enough about you to go to travel to Wisconsin and speak on your behalf. I'm sure that they'll take your collect call.
So I don't know what pleases you, Your Honor. I don't know what pleases the court, but
Again, they're the same thing.
I guess what I'm seeking is for enough time to know exactly who's going to be speaking, where they're going to be traveling from, and a little bit more information that I can provide to this court about the proceedings in Milwaukee County.
I understand your concern about the Milwaukee, but if I hold this on the 15th and the 16th, by your description of how many people, by what the state said, I think it's going to take about a day to hear the remarks from the parties, and then I would come fresh the next day to give the court's sentencing. And so probably a day and a half, but I'd set aside both of those days just to be on the safe side, in case it takes a little bit longer for either of the parties to present their sentencing remarks.
Your Honor, I'm not interrupting.
Go ahead. Go ahead.
I was trying to make sure I didn't interrupt you.
He wants something. Now that he needs something of the judge, he's being this nice person, but it's all an act. He just doing it. That's manipulation. He's being there just because he wants something.
Go ahead.
Your Honor, with all due respect, if it pleases the court, if it pleases your court, Your Honor, because of my situation, I could benefit from a little bit more time. I'm not asking for something outrageous here. Just enough that I can tie up some of my loose ends, get you the information that you need to be able, if someone has to be present by Zoom or whatever the case may be, or to find out if these people are actually going to travel. And also still be able to prepare for what I need to prepare for, because obviously I still, regardless to anything, I still have to be prepared to continue court proceedings. I still have to be prepared.
Prepare for what? You're not gonna do anything. Your lawyers are handling the other stuff. You need to be present for this.
It will really, really be a big help and a great benefit if I can have just a little bit more time to tie up the loose ends and get everything done in a timely fashion to be able to be ready to go and present what's needed to the court.
I understand that, sir. The issue the court has is, obviously, if I wait much longer than that, I would, out of respect for the victims, avoid the week of November 21st. That's also Thanksgiving week. I don't think that would be an appropriate time for sentencing. I mean, my calendar is just incredibly full. That puts us into January, and I'm not willing to do that. So,
yeah, she needs to do it at her time. She's not gonna care about what you have to do, because that's not her problem.
I think I'm giving the parties ample time. I'm giving alternate ways for family members to speak, and that is by Zoom or in person, should they wish to be here in person. And no matter what, that would still clear Mr. Brooks to be in Milwaukee on the 17th. I mean, we're one county over. It's not unusual to do an order to produce that close.
What I was gonna... Oh, I'm sorry.
Yeah, he's talking like if he tries to, he's gonna like go to Paris to be able to hear the other cases. It's just one county over. It's like an hour.
No, so I am gonna schedule it for the 15th and the 16th. That's my decision on that. I want to just very briefly have, I believe it's gonna be Deputy Kibler who's going to testify about the restraints.
Your Honor,
Yes,
but I'm not trying to interrupt.
go ahead.
You said, when is this supposed to be? Because I'm definitely gonna need a little bit more time than the 11th.
Well, she made her decision. You have to make it by the 11th.
Mr. Brooks, I've made my decision. The sentencing will be on the 15th and the 16th of November. Anyone who wants to appear by Zoom on your behalf, you must file a request in writing no later than noon on the 11th. The same is true for the state. Only those individuals who I specifically approve to appear by Zoom may be on the Zoom.
What if I'm placed on a protocol per the jail? What if
Mr. Brooks, that's between you and the jail at this point. If there is something you need to first go through them. I'm not going to step on their toes with their protocols. I'm sure they'll understand this is a very important sentencing for you and make certain accommodations. They've done that throughout this case. I trust that they will do that as they determine is appropriate.
Yeah, and I like that at this point the judge is just like, I'm not dealing with you. I'm just telling you what it is, and if you don't like it, then that's tough. If you have something to do with the jail, I cannot do anything about that. That's their deal. I like this. This should be the attitude of the whole trial.
they haven't done it for the past week when I went on a protocol without even telling them anything suicidal in nature, and I was still placed on a suicide watch protocol.
I understand that, sir. I need to move on because I do have calendar this afternoon, but I want to have Detective Kibler come to the stand. Kibler.
Your Honor.
Deputy, what did I say? Detective, did I give you a promotion? Sorry. All right. He's going to come on up to the witness stand. I'm going to swear him in, and we'll go from there.
For the record, may I respectfully object to your ruling, Your Honor?
It's noted for the record. All right.
What do you think that objecting to that is going to do? Do you think it's going to make her change her mind?
Madam Clerk, swear him in, please.
For the record, may I respectfully request a legal reconsideration
All right,
of your
Mr. Brooks,
ruling,
I'm
Your
going to
Honor?
have to mute you because I need to keep going, and I can't have this disruption.
He didn't allow him to read his script again. He's like, nah, you're out.
All right, thank you. And you are employed in what capacity with the Sheriff's Department?
I'm a deputy for the Waukesha County Sheriff's Department.
Were you assigned to the trial of Darrell Brooks?
I was.
And can you tell us in what capacity?
My capacity was, specifically, my responsibility was Darrell Brooks, along with Deputy Stengelson.
And were you in court at the start of the trial on October 3rd?
I was.
And did you come into court or work the court trial every day that we were in session?
I did.
Do you have knowledge of the restraints that were utilized on Mr. Brooks throughout this trial? Can you describe those, please?
It's a soft restraint that we used. It was not any type of electronic control device. It was just a soft restraint that we applied to Mr. Brooks prior to coming into court every day.
And would that be a restraint system that was on his legs or something else?
It was around his ankles.
All right. Throughout the trial, the tables in this courtroom had black table skirts. Do you remember seeing those?
I do.
And did that hide from view in any way the use of the restraints from the jury?
It did.
And were the restraints also attached to the table in some fashion?
They were attached to the table by a tether.
At any point in time, were there any type of electronic or stun device placed on Mr. Brooks?
There was not.
Sir, you indicated that the restraints were connected to the table through a tether, is that correct?
Correct, and then we would secure them with a padlock.
And how
on the
long was that
restraint.
tether?
The tether that was in here was 4 feet.
So Mr. Brooks could stand up?
Correct.
He could walk to his left briefly and walk to his right, is that correct?
That's correct.
And that was the same rule that the state had, that we had to stand up and use our table to question witnesses. That was the same rule that applied to Mr. Brooks.
Correct.
Okay, nothing further.
That's it. It was a strap. It was literally a rope or maybe something more resistant than that, and they would just secure it with a padlock. That was it. I don't know where he gets that it was a shock device.
Mr. Brooks, you're muted. Do you have any questions regarding the restraint system as testified to by
Yes.
Deputy Kimber?
Yes, I do. And Your Honor, you can't practice law from the bench.
This is not a witness. She can ask and say stuff. We're out of the evidentiary phase. It's just for the record.
Your question, sir?
So none of your fellow deputies told me that it was a shock device when I asked what was being placed on my ankles at the start of this trial?
Not that I'm aware of.
Not that you're aware of? Do you know for sure that I was told that they were a shock device?
I don't believe that's the truth. I believe every time you had those devices put on, I was in there, and it was either myself or Deputy Stengelson putting them on, and I did not tell you that, nor did I ever hear Deputy Stengelson tell you that they were an electronic device.
There you go. So it was a lie. There are only two people that could have told him that. It was him and the other detective or the other deputy. So it's a lie.
So you were here every single day for every single moment of the trial?
Correct.
And you never heard any deputy tell me that they were, matter of fact, let me back up. Do you recall
He always wants to back up.
me asking what was being placed on my ankles?
That I don't. If you did, we would have told you it was just an ankle restraint.
And you said that it was an ankle restraint. Did it have any metal parts?
Yes.
And what are those metal parts?
Metal part is where a strap went through and the locking device.
Yeah, it was like a belt. It was just like the thing that tied the rope with the padlock.
And what are those, particularly, let's say if a defendant in a trial attempts to, let's say, attack someone, what would be the purpose of those ankle restraints?
The restraints we had on you would limit your movement, so if you did try to do anything, we would have had enough time to control you.
The prosecutors stated that the same rules were in effect for the defendant as the prosecution, but were they not allowed to put up exhibits to go to the front of the courtroom and put
What is the relevance of that?
up exhibits?
They might have a few times, but
The record will reflect it was one time in the presence of the jury, and after that I called them on it and said that would not happen. And then after that, it was only with the permission of the court and then outside the presence of the jury.
I don't believe that, Your Honor, you can practice law from the bench and answer the question that was asked to the
Mr. Brooks, I'm in charge of the record, not you, and the record's going
I
to
didn't
be
say I was-
accurate.
I didn't say, well, it's not accurate. You're practicing law from the bench.
All right,
Law for the bench. And also, she can say whatever she wants. It's her record. It's her court. So whatever you believe, it doesn't matter.
Mr. Brooks, do you have any other questions for this
Yes, I
witness?
do. Yes,
All right,
I do.
it has
Before
to be
you start-
about the restraint system. Please
Okay,
continue.
and was I allowed to approach the bench and put up exhibits at any time during this trial?
you were not.
And so, how is it that the prosecution was able to do something that I was not able to do?
That's not for me to answer.
Yeah.
It's because of the shock device that was put on my ankles, correct?
There was no shock device on your ankle, sir.
I was told that it was.
By whom? Who told you that? I would love to know that.
And you said that you don't recall hearing that being told to me, correct?
No, it was not told to you by me.
Yeah, by you, but you also said that's the point that I'm getting at. I'm asking the question. You said that it wasn't told to me by you. I've never asked you, correct?
You never asked me, but I also did not ever hear Deputy Stengelson tell you that they were a shock
I
device.
never asked you. I never asked you, yes or no.
He really tries to limit the answer, but he doesn't ask it the right way.
No, you did not.
So do you know for sure if I ever asked any other deputies?
Well, considering I was in there when the restraints were being placed on you, I did not ever hear anybody while I was inside the bullpen. while they were putting restraints on you.
So it'd be fair to say that you don't know for sure if I ever asked what the device was that was being placed on my ankle.
No, I can't be for sure.
Fair enough.
So how do you know I didn't ask?
Because he was there every time. He was in the room. He never hear anything about it.
You don't have to answer that. That's argumentative.
I mean,
All right, the record's been
Okay.
made. Mr. Brooks, I'm cutting off the questioning. I'm just muting him for a moment. The record's been made. Deputy, you may step down. Mr. Brooks, if you have additional information that you want to provide to the court, I'd ask that you do so in writing, and you provide the identity of any and all individuals you claim provided you with information that you were in a shock restraint. But I'll make a finding based upon the testimony of Deputy Kibler and also my knowledge of being in the courtroom every day and seeing Mr. Brooks being attached, meaning they would secure him to the table, they would unsecure him when he needed to move and other things. I'll make a finding that the soft restraint system was what was utilized, and at no time was he ever in a shock type of device. All right, with that then, ladies and gentlemen, it is going to conclude the hearing today. We have the sentencing dates. I would also ask that any and all written material that either side wants this court to consider also be filed by the 11th by noon. So that's November 11th at noon. That will give this court ample time to review it ahead of the hearing on Tuesday, November 15th. All right, thank you, everyone. We are in recess. The court's going to take a short break before I start with my remaining afternoon calendar.
All right, so that was it. That was the scheduling. He made it a 10-minute meeting turned out to be like 2 hours just because he wanted to keep interrupting and doing his thing. But we're gonna come back next time. We're gonna do the final remarks by Susan. We're gonna do the final remarks by the judge. We're gonna do the final remarks by Darrell Brooks. So join me next time. We're gonna do all that stuff. So have a great day. Give it a like if you made this far. Bye bye.